on the police, and where it is exercised by the public, it has to be under very clear laws. Extension of time to comply with the regulations was another concern, because we were given 6 months to comply with the regulations, but unfortunately we are considering these in November, and therefore we will not have anything more than 2 months or 3 months to comply. There were many other of the regulations which are found in the report, and these were the concerns that we actually brought before the House, and it is on the basis of those inconsistencies that we actually made a recommendation that these regulations be annulled. Madam Speaker, having said all this, it is the considered opinion and recommendation of this particular committee that the regulations under consideration be annulled entirely in accordance with the law. Madam Speaker, allow me to thank members of the delegated legislation committee for their continued tireless work to ensure that all statutory instruments that are brought before the committee are scrutinized in time, reports are made timeously, those that are approved are approved, and those that are rejected are actually brought to this House to be annulled with the speed, so that the regulation making authority can go back to the drawing board and come up with regulations that are actually acceptable. With those remarks, it is my humble prayer, Madam Speaker, that you allow me to move and call upon the Honorable Member for Gilgil, Honorable Martha Wangari, to second. Thank you, Madam Speaker.
Honorable Wangari.
Thank you, Madam Speaker. I thank you for this chance to second this report, as has been ably moved by Honorable Murugara. And Madam Speaker, we have put a lot of time to these regulations as a committee, not only because it's an important regulation or piece of legislation, but also because it's a very sensitive matter, Madam Speaker, and we have considered so many of the issues that have been raised by the mover, especially consistency with the Parent Act, consistency with the Constitution, and consistency with other statutes. Madam Speaker, the issue of public participation, as has been alluded, is also included in Article 10 of the Constitution. The issue of inclusivity, the issue of accountability, the issue of transparency is actually a mandatory requirement. It is not optional. And Madam Speaker, we not only look at what the extent was, but we also, as a House of Records and that rely on evidence, require that regulation-making authorities are able to provide the necessary backup and backing documentation to be able to show that they have taken adequate time to go around the country for all the users and consumers of these regulations to be actually be appraised to up to where they should be. Madam Speaker, the committee has been open, very open, to regulation-making authorities in what we call pre-publication scrutiny, and this is something I'll say even to the others who are watching, that instead of coming with regulations that we cannot amend because we are not mandated to do that, we engage the committee before so that we are able to iron out the issues and be able to have a smooth sailing regulation-making process as has been mandated by the Statutory Instruments Act. Madam Speaker, in addition to what Honorable Gigi Murugara has said in his moving, I will only talk to some issues that led us to think that these regulations are fatally defective and will need to be relooked. I will take a chance to look at Regulation 25. Madam Speaker, this is an issue that has been very contentious in terms of arming security guards, and I know there is division of opinion on that, but more importantly, Madam Speaker, is that even if we go that way, we have to align it with the Parent Act. That has not been done. Madam Speaker, the issue of drafting is also fatally defective. If you look at Regulation 27 and the header, they provide for levy instead of what has been provided in the Mother Act, that is a fund. These are two entirely different things, Madam Speaker, and it will be confusing. The issue of timeline of implementation, Madam Speaker, it has been it had been put to February 2020. I know many security practitioners and consumers had said this time is too short. We are already in November. And the unfortunate bit is that we cannot amend to push that time unless we are able to pull out these statutory instruments and they publish again so that they are given enough time to comply, enough time to register properly their companies, to register into an organization, to be able to acquire the required instruments, to be able to acquire the proper equipment or the committee's report. You'll be able to see that the regulation making body provides for power to record and temporarily hold identification documents. Madam Speaker, that is in contravention with what has been provided for under the Parent Act or the Mother Act, that is the Private Security Act, Section 48(4). The other issue, Madam Speaker, is the issue of power of arrest. I know it has been touched to, but you know we live in a very enthusiastic country, that if you let people to just arrest you for no specific time, and you're not a police officer, and they do not say, after I arrest you, how long does it take to take you to the police or to a police station? It will mean a security guard can easily arrest you on a Friday, hold you wherever they are, take you whenever they feel like on Monday, and that, Madam Speaker, will be prone to abuse, and that issue is very critical, and that is why we are saying under Regulation 37, we must be very clear that it is in tandem with what has been provided for in issues of arrest under 46(4), clearly in the Parent Act. So, Madam Speaker, I know we have deliberated, and this is already explained very well in the report, and I say that we have very many reasons why we felt that these regulations are fatally defective, and I pray that this House sees the sense that we are talking of human life, we are talking of abuse of power, that we are able to annul these regulations in entirety, so that we are able to remedy these issues, so that we are able to align it to the necessary statutes, so that we align it to the Constitution, and so that we are able to do the right thing as we are supposed to do in this House. And with those remarks, Madam Speaker, I beg to second.
Order, members. The Kamukunji, you are louder than the member who is contributing. Please consult in low tones. Order. Order. Honorable members, I go on to propose the question, which is that this House adopts a report of the Committee on Delegated Legislation on its consideration of the Private Security General Regulations 2019, which is legal notice number 108 of 2019, laid on the table of the House on Wednesday, November 6th, 2019, and pursuant to the provisions of Section 18 of the Statutory Instruments Act 2013 and Standing Order 210-4B, annuls in entirety the said regulations. Is it the mood of the House that we put the question? I think until I get a motion, there seems to be some division. Members who want to contribute and those who want the question to be put. But you know the procedure, so I'll just go ahead and have Honorable Abdullah Sheikh, member for Mandera.
Thank you, Madam Speaker. And from the onset, I want to really congratulate the committee for the thorough job they have done. But just a key highlights of probably what they have done. These regulations, in the first place, there was no public participation. And these regulations actually will have had far-reaching implications on all the Kenyans. And therefore, not being able to do public participation as is required in the law itself is doing things against the law. When we looked at the report, it says that they only did public participation in Nairobi County out of the 47. So we were asking ourselves, who represented the other 46 counties? So that tells you that things were not done properly and they just wanted things done in a hurry. The other issue is the use of firearms. The regulations talks about a situation whereby all private security companies at some point in time will be allowed to carry or use firearms. Private security guards are not police officers, military officers, or Kenya Wildlife Service personnel, or prisons for that matter. the main act has not been changed, and yet here we have a regulation which says within 6 months, private security guards will be armed. That contravenes the main act, and is actually not even good for this country. We are not even yet there in a situation where we need to have guards being armed. And the other issue is the timelines. The regulations were published 3 months ago, and they are supposed to take effect to be complied within 6 months. 6 months itself is too short. When I look at countries more developed than us,
Honorable Gedi.
Madam Speaker, the Honorable Member is misleading people. There is nowhere where this regulation is seeking the private security to be armed. It is only the National Security Council that can approve. So, Honorable, as you debate, he needs to be guided, because it's not asking for arming of the private security.
Thank you, Madam Speaker. I beg to disagree, because this is a matter that I am conversant with a lot of expertise. The regulations has talked about, and those things have been in the media throughout, that the private guards will be armed, and that this will relieve duties of the police officers. So I beg to differ. Nevertheless, I wish to continue.
Honorable Sheikh, as you contribute, and Honorable Gedi, I believe the regulations are attached to a substantive law.
Yes.
So you debate within the substantive law and what the regulations speak to.
Thank you. And the other point I was trying to talk about is the timelines, where the security firms or companies were given 6 months to comply. As I was saying, we have drawn examples from countries which are more developed. If I look at the United Kingdom, they had similar regulations, but they gave the stakeholders 5 years to comply. Unlike in these regulations, the authority said it is 6 months within which companies to comply. It's too short, looking at the effects or ramifications of the regulations themselves. So as I support and agree with the committee in annulling the regulations, because I've gone through, and I don't want to really go back to each and every specific aspect, because the mover and the second have spoken about it. And the regulations actually will have had effects on the issue of the economy. We have had issues of where you say the minimum wages for the private security guards to be 35,000 per month. When you look at this, even the Kenya police officers, when they come out of training, that is not the much they are paid. So these are not inconsistent with even licensed or commissioned, gazetted officers that work with the police. Two, if you say you pay 34,000 to the private guard, how much will this security firm charge you as a client? That means the minimum they will charge is 50,000. As we know, no government institution or parastatal that normally accepts highest bidders. They always get the lowest bidder in terms of tendering processes. As we speak, no government institution or parastatal that is being charged by a security firm that is more than 30,000 per month. So if you are being charged 30,000 per month, you expect the security guard to be paid 34,000. Is that really working? It's not going to work. And that means if you want to force the companies to do the same, then where is the budget coming from for the government ministries or institutions to pay these security firms? So these are not things which are in tandem with the reality of the day-to-day affairs of the economy. So I really don't want to take a lot of time. I want to thank the committee for doing a great job in bringing this report so that this House agrees with them and annuls.
Regulations are, in my view, illegal, unlawful, and very punitive. But besides that, Madam Speaker, I have listened very carefully to the mover of this motion, who has said that we did not have adequate public participation. I think this is the very, very most important reason why these regulations should be annulled. Because you cannot conduct public participation in Nairobi alone. And we know that we have 47 counties where services of private security guards are required. So that was a big omission, and every time there is limited public participation, then there is always something sinister about what is about to be done. So that in itself offends the Constitution, particularly Article 10 of the Constitution, in terms of inclusivity. The second aspect, Madam Speaker, is inconsistency with the parent law. The parent law on security guards, private security guards. As has been said by the mover of the motion, that the requirement on firearms, that the private security guards will have access to firearms, that what should have been done before these regulations came for publication should have been the Parent Act needed to be amended to provide for the private security guards to hold guns. That has not been done. So we cannot make that huge proposal in regulation when the Parent Act says otherwise. The other thing is, Madam Speaker, I have read the regulations, and one of the very strange things in the regulation is that it allows the national security forces, the police commandant, to command the private security guards to participate in national security duties. Madam Speaker, this poses a major challenge to the employers of private security guards, that I have employed someone who is earning a salary from me, and then that person can be called anytime by another authority to participate in national security duties. I think there is some inconsistency there. And most importantly, we know that members of the private security guards, most of them are unionizable. The moment you get them involved in national security matters, it means they will cease to be unionizable. So we are going to kill the union that represents the interests of these people. The other reason, Madam Speaker, is conflict with the HR Human Resource Act. That I have employed someone who is under my control, but this person can be engaged in other duties. You raise the question that who pays them when they are engaged with the national security? And what if there are issues that may arise in that process, like they are injured or they are shot? Who is answerable? The regulations are silent on some of these questions. Then the issue of, in terms of requiring that these regulations must be implemented within 6 months. Madam Speaker, it's not practical, because these regulations were gazetted in July. So if we talk about 6 months, we are talking about January 2020, which is just 2 months from now. But some of the things that security companies are required to comply with.
Order, Honorable Shamala. I have not even given you the floor. So what is out of order?
The honourable member is being repetitive. He's simply echoing the sentiments and the words and the expressions that have already been used when the motion was being moved.
Honorable Shamala, the Honorable Osotsi has a right to his words, and it's his time.
Thank you.
Maybe he just wants to lay more emphasis on what has been said, and it is allowed, as long as he remains relevant. Go on, Honorable Osotsi.
Thank you, Madam Speaker. I think it is important to emphasize these issues as well, because I've also read the report. So, Madam Speaker, I'm saying that the requirement, compliance requirement, are so difficult to comply with in the next 2 months. For example, the requirement of saying that they need to have an armory, they need to train people and all those kind of things. It is not possible to comply. So that means many of our security companies, especially small security companies, will simply close shop, and many security guards are going to lose jobs. So for that matter, Madam Speaker, I support the motion.
Now, is the Honorable Thuku Kwenya ready to contribute?
Indeed. Thank you, Madam Speaker. I rise to support the annulment of the said regulations on the grounds that have been well moved by the mover. And as much as maybe I'll mention a few things that have been said, I believe that Honorable Shamala will not be in a position to say that I'm repetitive. But nevertheless, I wish to state that there are many reasons as to why the said regulations should be annulled. One, they are foreign. They are not Kenyan. The reason as to why I say this is that for the simple reason, the period at which security reigned. The other issue that actually caused me to have an eye and look at these regulations is the issue of insufficient public participation, because security guards are not a preserve of Nairobi County only. We have other counties that have interest in, actually the whole country has interest in this, because private security companies complement the work that is done by the National Police Service, and actually now telling these small private companies to be in compliance by 20th January of next year is simply not is not achievable. Security companies that are compliant and that can comply within that period. We know there are few giants that we have, and this maybe begs this question: who drafted these regulations? Because the intention seems to have been to drive the small players out of market, and therefore I strongly support the committee's position. You can imagine a security firm being asked to pay their security guards a colossal amount of 35,000 per month. How many people can afford even to hire a security guard to guard their homesteads? How many companies can afford and make profits out of the people that they employ? The other issue is, how is it that the drafter of the said regulations proposed that there be a private security regulatory authority whereby only 2 of the representatives would come from the industry players, the rest to be from outside? We have not seen an organization or a regulatory authority whereby foreigners or people who have no interest in the industry are the people who are appointed to regulate. And therefore, I strongly support the delegated committee's position to annul the said private security regulations. Thank you, Madam Speaker.
I serve in this committee of delegated legislation, and I sincerely want to say that this committee is a very serious committee. They leave nothing to chance. And if you can remember, Madam Speaker, is that we have approved so many regulations. This one seemed to be the worst regulation ever since that I have sat in this committee, because, Madam Speaker, public participation is mandatory as far as the Constitution is concerned. And when the regulation authority, making authority appears before us, they told us that they did public participation in 47 counties, and yet they could only evidence only 1 county, Nairobi County. So, Madam Speaker, we gave them 2 weeks to submit all the records from the county, county commissioner's office, showing the public participation, they were not able to do that, meaning whoever was making this regulation had bad intention, Madam Speaker. Number two, Madam Speaker, the private companies that provide security services, they have about 500 employees. And the only companies which seem to have qualified are foreign companies, well, and there are only 5. Meaning the intention was to get rid of the local companies and only remain with the foreign companies, which will subject the cats jobless. Yet, we should be making regulation that will assist the country to create more jobs, Madam Speaker. Madam Speaker, it is my personal observation and advice to any regulation authority making to apply the pre-scrutiny publication, so that when they are bringing up their regulation, they will have engaged the committee to agree, and so that we're able to...
Honorable Serone,
Yes, Madam Speaker.
pre-scrutiny publication?
Republication scrutiny.
Yes, I think that's better.
Yeah. Madam Speaker, that is the only way that any authority making regulation need to follow, so that their regulations are passed in time, instead of wasting a lot of time and public money in processing this regulation. Madam Speaker, I don't want to repeat so much, but the issue is, it is my feeling that for these companies, they need to be given at least 3 years in order to register and train their personnel. Otherwise, 3 months does not make sense, Madam Speaker. Therefore, Madam Speaker, I support the annulment in totality. Thank you, Madam Speaker.
The Honorable Koi Waluke is not ready. The Honorable Jennifer Shamala.
Thank you, Honorable Speaker. As I rise to support, I wish to make certain things very, very clear to the House. That the reason for the annulment of these regulations were 2. One of them was the issue of not being able to provide the evidence for public participation. Indeed, when the ministry and the stakeholders appeared before us, the permanent secretary had indicated that they had sent circulars to all the 47 counties through the county commissioners, and had undertaken to provide this circular to the committee before we sat for deliberations, which was a few days later. By the time we sat to deliberate on this, we were still to receive evidence of this circular. The second reason for the annulment, and there were only 2, was that there were no clear standard operating procedures with regards to control and command between the police service and the security guards. Having said that, I remember that they appeared before us, various stakeholders, and one of them was led by a gentleman who was the head of the unions for security guards. And actually the complaint was that they are amongst the most poorly paid sector in Kenya. What happens is that you have a security guard in an unregulated industry whereby the security companies may be taking over and above 30,000 per security guard and only paying him 10,000 or maybe 8,000 shillings, no uniform, no shoes, no coat, and nothing even to defend himself with. And it was for these very 2 reasons that we recommended the annulment of these regulations. In the event that the ministry will come back and satisfy these 2 regulations, we shall, in the interest of the over 500,000 security guards in this country, approve those regulations. With those few remarks, I support.
Well said. Let's have the Honorable Member for Funyula, Honorable Oundo.
Honorable Speaker,
Honorable members, if you want the mover to reply, you know what to do. So don't shout from your seats. Go on, Honorable Oundo.
Honorable Speaker, thank you for this opportunity. I sit in the committee, Delegated Legislation Committee, and I had an opportunity to listen to the presenters and other stakeholders. Honorable Speaker, I do not want to repeat what my colleagues have talked about, public participation and the rest. Just allow me to make a few comments, and specifically in regard to various provisions. Honorable Speaker, I was alarmed, like any other members of the committee, on a provision that gave the commanding officer of a nearby police station the unfitted authority to call upon the members of the private security guards to provide security in national interest. Honorable Speaker, I saw that as an extremely dangerous situation, dangerous provision that has got the end result of plunging this country into chaos. Honorable Speaker, I just recalled that after the 2017 elections, there were very many protests and picketing and demonstrations in support of the elections or in opposition of the elections. I just imagined if you got a rogue OCPD would simply collect, whether licensed or not, private security providers to come and assist in quelling those riots. And considering, Honorable Speaker, that these private security guards are not adequately prepared and trained, there was going to be chaos. Secondly, Honorable Speaker, the most dangerous provision as well was that required that in the event that the security privacy or the person whom he has been requested to arrest or quell a riot suffers injury or damages, and that person, the victim, sues, then the private security guard is personally held liable for any damages that may be awarded by a court of law or by any other competent authority. Honorable Speaker, many of the boys and girls who join the private security guards do not have the wherewithal to meet those kind of damages in the event they are asked to pay. Honorable Speaker, for that reason and many other reasons, I personally and the committee generally felt that these regulations were premature, drafted with a sinister motive, and were going to hurt the intended beneficiaries more than they were going to benefit them. Honorable Speaker, the period given to comply is extremely too short. It takes 18 months currently to train a competent police officer. It takes much more to train that police officer on the job to understand the ropes of the job. The security guards, private security guards, normally go through very rudimentary training. The period left between gazettement of the regulations and compliance of the regulations is effectively 2 months. You can never train a security guard to understand the tenets of providing security within 2 months and expect him or her to provide or operate at the same level as a qualified police officer or security agent. On those few remarks, I support the committee's decision that calls for the annulment of the regulations that needs to be thoroughly reworked on before they are brought before the committee for review and approval. Thank you, Honorable Speaker.
The Honorable Koi Waluke.
Thank you, Madam Speaker, for giving me a chance also to speak on this. Madam Speaker, on onset, I support the report, Madam Speaker. It's a good report, but I annul the regulations, Madam Speaker, should be annulled. This country, we have enjoyed peace, Madam Speaker, because of accountability of the weapons, and not like any other countries where firearms are just allowed to anybody to walk with it, like Southern Sudan and other countries, Madam Speaker. So we need that peace to continue to this country, Madam Speaker, so that our young people who are coming up, our children also should enjoy the way as we have enjoyed, Madam Speaker. Madam Speaker, the regulations should be nulled and go back to the drawing board, Madam Speaker, because the period that they have given is a very short period. To train a soldier, Madam Speaker, to use a firearm, it takes more than 12 months, Madam Speaker, for a soldier to understand, to strip the weapon, to put it back to how it is supposed to be, Madam Speaker. Sometimes we lack control even to our police officers in this country, Madam Speaker, and that is why you have been seeing and witnessing police officers shooting their families, their wives, their colleagues, because they have just been left with the guns, the firearm, to stay with the firearm in their houses. And this, Madam Speaker, has caused these countries or some families to lose their loved ones because of lack of control and accountability. It should be like in military, Madam Speaker. I was there. When you sign for a firearm, you must return it, and when one bullet misses, you must report, and you must state how that bullet got lost, or how did you fire the bullet without any reason. And this should apply to even our police officers, GSU, AP, prison, and world warden, Madam Speaker, who holds the firearms. And in this, Madam Speaker, will control and limit the death of the innocent people, sometimes who are just killed. Madam Speaker, in this country, we have many forces. Not that maybe we went to the war and soldiers, all of them have died, that now we can bring the private security cards also to be given, to be allowed to hold firearms, Madam Speaker. And of late, we have seen them, Madam Speaker, even on the CCTV. They have become thieves, many of them. They are stealing. They collude even with our police officers, Madam Speaker. Stealing the banks, stealing even in the supermarkets. And when they are allowed to hold guns, Madam Speaker, this country can turn into something else. So we need like 5 years for the public participation, Madam Speaker, not even 1.5 years, no. This is a very important issue to this country, Madam Speaker, and we cannot just allow a private card to hold a gun, no. And this, Madam Speaker, this house is a house of laws, and we should follow the laws and the Constitution also, Madam Speaker. That somebody, even if he's a member of Parliament, Madam Speaker, they should not just be allowed to take, to be given a firearm if they have not been trained to use a firearm, Madam Speaker. Because sometimes you see some of us walking with a firearm, showing anyhowly to anybody. You want people to see that you have a gun. This should also be limited, Madam Speaker, because some of us don't even need to have firearms for the show. The way some of us behave, Madam Speaker, is not also good. Control must be there, A firearm is something that cannot just be allowed to somebody who has not or never trained to use a firearm, Madam Speaker. So for those few remarks, Madam Speaker, I support the report. Thank you.
Honorable Nyoro Ndindi. Is it Ndindi or Ndende?
It's
I need
Dende.
to understand, is Ndende or is it Dede?
It's Dede.
Dede.
Dende.
Honorable Dede Nyoro.
Kabisa. Thank you very much, Madam Speaker, for the chance to support the annulment of the private security regulations. Madam Speaker, I have gone through the report by the committee, and I actually can't agree more with them. Madam Speaker, the issue of saying that private security guards can collaborate with the police officers who are employed by the public, Madam Speaker, without proper guidelines, Madam Speaker, is a step in the wrong direction. Madam Speaker, there is no way a private person employed by the private sector can also take and obey orders given by the police bosses. Because, Madam Speaker, number one, the training that our police or the members of our police service, Madam Speaker, undergo, the private sector has no that privilege to take their private guards to such kind of thorough training, Madam Speaker, and especially in handling firearms, Madam Speaker. But also, Madam Speaker, something that is unfortunate with the regulations as it were, was that we can give powers to arrest where a private person purporting to be a private guard can actually arrest anyone, keep you in their house, and then take you to court or to wherever place after some few days, Madam Speaker. And therefore, it is not wise for us to expose our country to those kind of risks, Madam Speaker. But even more telling is the fact that the drafters of the regulations never saw the need to do thorough public participation. Madam Speaker, the issue of security is not just based in the city of Nairobi. The issue of security or lack of it is also found in Murang'a, in Busia, in Suba East, or any other place, Madam Speaker, in this country. And therefore, Madam Speaker, we are creating one. And therefore, Madam Speaker, it was important for the drafters to go around the country in every corner, because the issue of security affects the all and sundry, the mighty and the lowly. And therefore, it is important for them to conduct proper public participation, and not just the academic, to actually also affect the price on which we actually purchase these services. Because private guards, they give out a service, and it's also the private sector that actually pays for this service. And it is actually not the business of this house to actually regulate the prices of labor in this country. Because if we say a private guard would be paid this much, Madam Speaker, without even saying how much the private security will charge their clients, Madam Speaker, that is a defeatist argument. Maybe what they ought to have done is actually to put a percentage that if, for example, I'm the client as the Parliament of Kenya, procuring services from a private company, maybe I should be compelled to give a certain proportion of the money that I charge my clients to the servicemen and women who serve as private guards. But I don't think it's the prerogative of this House, Madam Speaker, to actually give the actuals in terms of a figure, because there are also other dynamics. Inflation comes, and also the monies that you are actually proposing may be overtaken by the events of time. Madam Speaker, also, we have to ask ourselves this question. Why do we actually have a police force? And not just a police force. Why do we actually have some services being rendered by the government or the public sector, as we call it? Madam Speaker, to my understanding, the reason why we have a police force in this country, just like any other public service, is because there are some services that I cannot be able to procure as an individual. And there
Madam Speaker, I don't believe the money that we normally put there is the same as the work which these people normally do. I've never seen anything that National Youth Service do. Sometimes we are told they do roads, but I've never seen serious roads they have done. Sometimes we are told they do, I don't know what. We don't see those serious things which they do. So, Madam Speaker, my opinion is that instead of actually arming the private security guards, the government should create a wing within NYS that will be trained as security. And this is a part which can be armed because they will be...
for
Emurwadi.
Dikiri.
Yes, madam.
Kipyegon Ngeno,
Yes.
Honorable. There's an intervention by the Deputy Minority Whip.
Good.
The Honorable Member for Katiani.
Minority Leader.
Minority Leader.
Thank you, Madam Speaker. Madam Speaker, I'm standing on Standing Order 95, and looking at the mood of the House, would I be in order to call that after he finishes his contribution, we call upon the mover to reply, and this is guided by the fact that we also have a lot of other reports that we should finish by the end of the day today.
Very well. Before I prosecute the minority leader's point of order, allow the member, Honorable Kipyegon Ngeno, finish his debate on this.
Thank you, Madam Speaker. I was just almost finishing. Madam Speaker, I was just saying that the members of the NYS should be trained. There should be a section in the NYS wing that should be trained as guards, should be armed, and these are the people who should be allowed to do all these security things. Madam Speaker, you know we are taking so many policemen.
Honorable Musimba, Honorable Musimba, we don't do that. We don't bang, you know how. Yes. Your circulation, yeah, that's not how we clap. You know there's, thank you.
Madam Speaker, maybe just to proceed, you know, Madam Speaker, we have used policemen and police officers in guarding several institutions and personalities. Madam Speaker, I think if we were to create a section in the NYS, even members of parliament can be guarded by those people. Members of Senate can be having their securities from NYS. Governors can be having CSS and all that. So that we leave the police officers to do exactly what they are trained to do. So, Madam Speaker, instead of bringing back this thing, I wish the proponent of this particular amendment should bring it in form of creating a wing in NYS to train a security section that will help in matters of security. Thank you, Madam Speaker.
Very well, well spoken. You know, Honorable Musimba says he wanted blood circulation in his hand. In fact, he was not clapping, he knows how we do it. Point taken. I move to prosecute the minority leader's point of order, and it stood on Standing Order number 95 on closure of debate. From where I sit, the House will have to take a vote. I put the question, which is that the mover be called upon to reply. Will as many as of these opinions say aye? Aye. As many as of contrary opinions say nay? Nay. The ayes have it. The mover to reply.
Right. Madam Speaker, thank you very much. Thank you very much. I beg to move to reply and thank the honorable members of parliament for their very passionate debate, lively debate. I believe the regulation making authority now has the opportunity to comply, while the particular service providers in the private security firms will have to train them well and make them ready for this particular liaison that is to come in between the disciplined forces and the security personnel. There will also be room for professionalism so that those who get into the private sector are professionals who can actually be termed as quasi or paradisciplined force. So with those remarks, I beg to reply to the motion.
Very well. Honourable members, from where I sit, we have the House is not properly constituted for me to put the question. And so I do order that the question to motion number 11, that is annulment of the private security, General Regulations 2019, be put in the next sitting as it will appear in our order paper. Next order.
Order number 12, motion annulment of the Public Service Commission Regulations 2019.
The chairperson, Committee on Delegated Legislation, to move.
Honorable Speaker, Madam Speaker, thank you very much. I beg to move that this House adopts the report of the Committee on Delegated Legislation on its consideration of the Public Service Commission Regulations of 2019, legal notice number 65 of 2019, laid on the table of the House on Wednesday, November 6, 2019, and pursuant to the provisions of Section 18 of the Statutory Instruments Act 2013 and the Standing Order 2010-4B, annuls in its entirety the said regulations. Honourable Speaker, the Committee on Delegated Legislation is established pursuant to the provisions of Standing Order 210 with the power to scrutinise all statutory instruments submitted to the House and to certify and ensure that these instruments comply with the Constitution of Kenya and all applicable laws. The committee is expected to consider in respect of any statutory instruments whether it is in accordance with the provisions of the Constitution, the Act pursuant to which it is made, or other relevant written laws. Standing Order 210(3) and Section 13 of the Statutory Instrument Acts further provides that scrutiny of any published instrument shall be guided by the principles of good governance, the rule of law, and various considerations such as any defects in drafting, expenditure from their consolidated fund, or other public revenues, unjustifiable delay in publishing or laying before Parliament, etc. Madam Speaker, the Public Service Commission Regulations of 2019 were made by the chairperson of the Public Service Commission pursuant to Section 92 of the Public Service Commission Act of 2017. The regulations were published in the Gazette vide Legal Notice number 65 of 2019 on the 24th of May 2019. These regulations were then submitted to the Clerk of the National Assembly on the 5th of August 2019 and tabled before the House on the 11th of August 2019. The regulations seek to operationalize the Public Service Act 2017 by giving effect to the mandate of the Commission pursuant to Section 92. The regulations also provide a framework to assist in better running of the public service. Specifically, the regulations sought, amongst others, to provide the form and method of keeping records, to provide the appointment and discipline and removal of staff against the Constitution, the Interpretations and General Provisions Act, the laws of Kenya, the Public Service Act, and the Statutory Instruments Act. And pursuant to Section 16 of the Statutory Instrument Act, the committee held a meeting with the Regulation Making Authority and the Ministry of Public Service, Youth and Gender Affairs on 4th October 2019 and 1st October 2018. The committee observed that with regards to consultations and public participation, as provided for under Article 10 and 118 of the Constitution of Kenya, and the various sections 5.5a of the schedules to the Act and Standing Order 210, where it requires the regulation making authority to conduct public participation and sufficient consultations with the stakeholders, the outcome of such consultations are to be indicated within the explanatory memoranda in detail. It was observed that the explanatory memoranda submitted by the regulation making authority did not demonstrate that sufficient public consultation. The regulations were published via a Gazette notice on the 24th of May 2019 and submitted to the clerk on the 5th of August 2019. and tabled in this House, before this House, on the 11th of August. This was 14 sitting days outside the statutory timelines stipulated by Section 11 of the Statutory Instruments Act. There was unjustifiable delay in the transmission of these regulations, contrary to Section 13J of the Statutory Instruments Act. Furthermore, regulations 22, 47, 49, 52, and 53 inappropriately delegated legislative powers, contrary again to Section 13M of the Statutory Instruments Act. The regulatory impact statement, Section 6, 7, and 8 of the Act requires the regulatory making authority to carry out a regulatory impact assessment and submit to Parliament a regulatory impact statement if the proposed regulations have significant costs or impact to the community. Madam Speaker, having examined the PSC Regulations 29 against the Constitution of Kenya and all other legislation, the committee recommends that the House annuls in entirety the said statutory instruments for contravening sections 5, 5A, 11, subclause 1, 13J, and 13M of the Statutory Instruments Act 2013. Madam Speaker, as I conclude, allow me, and I can never say this too many times, and none of us can, and in the Committee of Delegated Legislation, to really thank the tireless efforts of all the members of the Committee of Delegated Legislation. Their exceptional commitment and great work ethic is really a spirit of excellence, and it ensures that the committee delivers on its mandate. Madam Speaker, I therefore beg to move. I do request that Honourable Robert Mbui, member for Kathiani constituency and a member of the committee, to second the report. Thank you.
Honourable Robert Mbui.
Yeah, thank you, Madam Speaker. Madam Speaker, I stand to second the report that seeks to annul the Public Regulations 2019. Madam Speaker, much as I'm standing to annul these or to support the annulment, I must maybe begin by mentioning the positive, because there's always a positive in every regulation. And the positive is the purpose of these regulations. The purpose of these regulations, Madam Speaker, is to operationalize the Public Service Act 2017 by giving effect to the mandate of the Commission pursuant to Section 92. And these regulations, Madam Speaker, they also provide a framework to assist in the better running of public service. So basically, it's an excellent idea, because what we have noticed is that when it comes to issues to do with appointment of staff in the public service, there was a lot of abuse of the process, because you know that after the last election, for example, there was a lot of people that were employed in the public service, and I think the Public Service Commission feels that they really did not follow the letter and the spirit of the law. So basically, that is why these regulations, that obviously we cannot give them a blanket check, because that would mean that they can go and make changes to the law without consulting Parliament anymore.
Of the reports. Other members, I propose a question, which is that this House adopts the report of the Committee on Delegated Legislation on its consideration of the Public Service Commission Regulations 2019, legal notice number 65 of 2019, laid on the table of the House on Wednesday, November 6, 2019, and pursuant to the provisions of Section 18 of the Statutory Instruments Act 2013 and Standing Orders number 210-4B, annuls in entirety the said regulations. I can see interest to speak to this. Can you members? Allow me give the member for Taveta first.
Asante sana Mheshimiwa Spika. Mimi nami nataka kuchukua fursa hii kuunga mkono kuwa kanuni hizi za kusimamia masuala ya tume ya wafanyikazi wa umma hapa nchini ni sawa kuwa itupiliwe mbali, kwa sababu hawakufuata mwafaka ambao unaotakikana. Mheshimiwa Spika, vipengele katika katiba yetu vinasema wazi kuwa umuhimu wa kuhusisha umma kwenye masuala yote ambayo yanahusu wananchi na haswa masuala ya huduma kwa wananchi. Na Mheshimiwa Spika, ukweli ni kwamba saa nyingine utakuta wafanyikazi wa umma kwenye serikali wanafanya kama utani kuwa wananchi hawatakani kuhusishwa. Hivyo basi kamati hii imefanya kazi nzuri ya kuhakikisha kuwa swala hili linatupiliwa mbali. Lakini vile vile ningependa tu kusema nimekuwa na wasiwasi kwamba tume hii ya kusimamia wafanyikazi wa umma ni tume ambayo inatakana kusimamia wafanyikazi wote kwa ujumla, na tunajua kuna ngazi mbili hapa nchini. Kuna ngazi ya juu ambayo ni ya kitaifa na ngazi ya pili ni ya ugatuzi. Lakini wameshindwa kuangalia jinsi wataweza kuhakikisha kuwa wafanyikazi wa umma wote wanaangaliwa kupitia tume hii ambayo kwa kweli ni ya kitaifa na ya kusimamia wafanyikazi wote wa umma hapa nchini. Mheshimiwa Spika, hayo ndio masikitiko yangu makubwa, lakini juu ya hapo naunga mkono kamati hii.
Unaunga mkono kamati hii. On my request list, the member for Kitutu Chache, but I can't see him in the house. I'm sure he's consulting. Member for Suba North, she's also consulting. Member for Funyula. The member from Funyula, you don't want to speak to this. The member for Tharaka, you want to speak to this?
I do have an intervention.
Member for Funyula, you want to speak to this before I go to your intervention? Member for Tharaka, you
Yes,
want to speak
I
to
do
this?
have an intervention.
My question is, do you want to speak to the debate before we go to your intervention?
No.
You
It's
do
an
not
intervention I have.
It's an intervention you
It's
have.
an intervention I
Before
have. Thank you.
I give you. Sirisia? Yes, member for Tharaka.
Yes. Thank you, Madam Speaker. Madam Speaker, I raise understanding order 95, and in view of the fact that we have had a very lively debate on this, I request that you call upon the mover to reply.
Very well. This, from where I sit, is not an abuse of proceedings of the House. You are quite in order, standing order number 95. Actually, in fact, only 3 members wanted to contribute to this. The member for Sirisia, who is not in the House. The member Suba North, she is consulting, that is Honorable Odhiambo Milia Koth. And the member for Funyula, Oudo Ojiambo, who went into record to say that he's not ready to contribute to this. So this is not an abuse of proceeding of the House. And I move to put the question, members, as a matter of procedure of the House, for the mover to reply. Will as many as of the opinion say aye? And as many as the contrary opinion say nay? The ayes have it. Mover to reply.
Thank you, Madam Speaker. I rise to reply and do not want to belabor the point because all valid points have been made. Most importantly, that the purposes for these regulations were extremely, extremely important. Unfortunately or fortunately, the Committee on Delegated Legislation is guided at all times by the Statutory Instruments Act, which has strict timelines that have to be adhered to, and one cannot step out of these timelines. It is our and my humble submission to all the bodies that have to engage with the Committee on Delegated Legislation that they become and make themselves conversant with the Statutory Instruments Act. And most importantly, the Committee on Delegated Legislation is always there for pre-public scrutiny, pre-publication scrutiny. So before you even go and publish these regulations in the Kenya Gazette, please approach the Committee on Delegated Legislation and we will give the necessary advice. With those few remarks, Madam Speaker, I beg to reply.
You beg to reply. Honourable members, we are not in a position to put the question to motion number 12. on the annulment of the Public Service Commission Regulations 2019, and so putting of the question of the same is deferred. Next order.
Order number 13, annulment of part of the political parties funding regulations 2019.
The mover to move, that is the chairperson, Committee on Delegated Legislation. You're the chairperson? Officially in record? I've confirmed from the clerk. Yeah, thank you. You can move.
Honorable Speaker, on behalf of the chairperson of the Committee of Delegated Legislation, I beg to move that this House adopts the report of the Committee on Delegated Legislation on its consideration of the political parties funding regulations 2019, legal notice number 143 of 2019, laid on the table of the House on Wednesday, November 6, 2019, and pursuant to the provisions of Section 18 of Statutory Instruments Act 2013, and Standing Order 210, subsection 4, paragraph B, announce regulation of 18 of the said regulations. Honorable Speaker, the Committee on Delegated Legislation is established pursuant Standing Order number 210 with the power to scrutinize all statutory instruments submitted to the House and to certify that this and ensure that these instruments comply with the Constitution of Kenya and all applicable laws. Honorable Speaker, Standing Order 210(3) and Section 13 of the Statutory Instrument Act provides that scrutiny of any published instrument shall be guided by the principles of good governance, rule of law, and various considerations such as any defects in drafting, expenditure from consolidated fund, or other public revenue, and justifiable delay in publishing or laying before Parliament, etc. Honorable Speaker, the political parties funding regulations 2019 were made by the Registrar of Political Parties pursuant to Section 49 of the Political Parties Act 2011. The regulations are vital in giving effect and enhancing implementations of the Political Parties Act 2011. The regulations were published in the Kenya Gazette via legal notice number 143 of 2013 on 9th August 2019, received by the Clerk of the National Assembly on 29th August 2019, and tabled in the House on the 11th September 2019. Honorable Speaker, the regulations are intended to enforce Part 3 of the Political Parties Act 2011 and Section 23, of which establishes the Political Parties Fund to be administered by the Registrar of Political Parties. The regulations seek to revoke the Political Parties Funding Regulations of 2009, legal notice number 169 of 2009. The regulation provides the duties of the Registrar of Political Parties in the management, accounting, and application of the fund. Regulation 18 requires the registrar to set guidelines regarding the disbursement of monies from the fund to any political party, program, or activity, the rules and procedures related to the disbursement and management of the funds. Honorable Speaker, the Committee on Delegated Legislation held pre-publication scrutiny of the instruments pursuant to Section 16 of the Statutory Instrument Act 2013. The committee invited the regulatory making authority, being the Registrar of Political Parties, to a pre-publication consultation on 14th June 2018 and 30th November 2018, where the Registrar of Political Parties presented the draft regulations to the committee and responded adequately to all concerns raised by the committee members. With the regulations having been published on 9th August 2019, the committee and committed to the committee on 11th September 2019 for scrutiny, the committee scheduled the business on 3rd October 2019 and took into consideration the pre-publication consultation previous held with the Office of the Registrar of the political parties. Honorable Speaker, having listened to the regulatory making authority and examined the regulations against the Constitution, other relevant laws, and the committee made the following observation. 1. The regulations were submitted to the National Assembly within the statutory timelines contemplated under Section 11(1) of the Statutory Instrument Act, having been published on 9th August 2019, received by the Clerk of the National Assembly on 28th August of 2019, and tabled on 11 September 2019. Secondly, the regulatory making authority demonstrated to the committee that adequate public participation was conducted. The following key stakeholders were consulted: political parties, the Independent Electoral and Boundaries Commission, the Kenya Law Reform Commission, the judiciary, the Political Parties Dispute Tribunal, the Office of the Attorney General, the National Gender and Equality Commission, and the Kenya National Commission on Human Rights. Honorable Speaker, thirdly, it was observed that the regulations do not require a regulatory impact statement, since they are intended to make provisions for the structured guidelines for the management, the application, and disbursement of the Political Parties Fund established under Section 23 of the Political Parties Act. Honorable Speaker, number 4, the committee noted that there was inappropriate delegation of power. Section 13M of Statutory Instrument Act prohibits the regulatory making authority to legate powers that are already delegated. Consequently, the committee observed that Regulation 18 inappropriately delegates legislative powers to the registrar, giving the registrar power to set guidelines, conditions, and requirements for the management of the fund. Guidelines are statutory instruments within the meaning of Section 2 of the Statutory Instrument Act, and if made by the registrar, must be submitted to the National Assembly to be considered by the committee. This in contravention of Section 13M of the Statutory Instrument Act, which requires the committee during scrutiny to check whether the regulations inappropriately delegates legislative powers. Honorable Speaker, having examined the Political Parties Funding Regulations 2019 against the Constitution of Kenya, the Interpretations and General Provisions Act, Cap 2 of the Laws of Kenya, the Political Parties Act 2011, and Statutory Instrument Act number 23 of 2013, and pursuant to Standing Order 210(4)B and Section 15(1) of the Statutory Instrument Acts, the committee do not accede to a part of the Political Parties Funding Regulation 2019 and recommends that the House annuls Regulation 18 of the Political Parties Funding Regulation 2019 as inappropriately delegates legislative powers to the registrar of political parties to set general guidelines, conditions, and requirements for the management of the fund, contrary to Section 13M Statutory Instrument Act. Honorable Speaker, as I conclude, allow me once again, and we shall never tire to say this, to acknowledge the tireless efforts of the members of the Committee on the Legal Legislation for their exceptional commitment to great work ethic and spirit of excellence to service in ensuring that committee delivers on its mandate. As we have always said before, we are truly honored and humbled to be servants to the people of Kenya. Honorable Speaker, I beg to move, and I request Honorable Robert Mbui, member for Kothiani constituency and member of the committee, to second the report. Thank you, Honorable Speaker.
Deputy Leader, Minority.
Yeah, thank you, Madam Speaker. I rise to second the motion that this House adopts the report of the committee to annul Section 18 of the Political Parties Funding Regulations 2019. Madam Speaker, we've had quite a number of reports, and I think a lot of them, out of the 4, 3 of them we are actually proposing annulment. And I remember one time we were in a committee meeting and a chair of a committee, I will not name here, said that this seems to be an annulling committee. And especially when we use the words that we annul in its entirety, they were shocked. But Madam Speaker, the reasons is because we are guided by the law. The fact remains that even the Statutory Instruments Act that we use gives any regulatory making authority an opportunity to consult with this committee even before they publish. The problem is, Madam Speaker, we keep facing situations where regulatory making authorities, because every act of parliament seems to identify the regulatory making authorities and gives them powers to make regulations. Whenever they get those powers, they decide to make these regulations without following the Statutory Instruments Act, which is a law and which must also be followed. So I think I would like to advise that they consider the pre-publication scrutiny, where they do publication before they do a draft, and before they publish it in the Kenya Gazette, they have a sitting with the committee, because it is allowed. It is in the law. It is in the Statutory Instruments Act. Madam Speaker, now, I would like to maybe just point out, because I know regulatory making authorities will refer to this, because even those that we have annulled will want to know why. Maybe I would like to just point out, what does the Statutory Instrument Act provide for? And it actually provides for the making, scrutiny, publication, and operation of statutory instruments for matters connected therewith. Madam Speaker, it would be important to also identify what exactly is a statutory instrument, because I have noted that there is a lot of laws that are being made outside this house. And yet the law, Statutory Instruments Act, is very clear that now let me quote what the law says, that any rule, order, regulation, direction, form, tariff of costs or fees, letters patent, commissions, warrant, proclamation, bylaw, resolution, or guideline forms statutory instrument. So it is unfortunate that a lot of times these regulatory making authorities forget to understand what whatever a statutory instrument really is. And Madam Speaker, what we do is we follow Section 13, which gives us a guide on the relevant considerations that the committee must follow in order to make its decision. And some of them, Madam Speaker, allow me to just point out, is consistence with the Constitution and the Parent Act. So if it is any regulation, it has to be within the Constitution, and it must also be subjected to the Parent Act. Many times we see regulatory making authorities going outside the Parent Act and giving themselves powers and talking about things that are not in the Parent Act. Also, we have to ensure that it does not infringe on fundamental rights and freedoms of the public. We have to ensure that it does not contain a matter which, in the opinion of the committee, should be more properly dealt with by an act of parliament. So they don't make any new laws within the statutory instruments. Should not contain imposition of taxes unless allowed by the law. Does not bar the jurisdiction of the court. Does not give any retrospective effect or to any of the provisions. Does not involve expenditure from the consolidated fund. We saw that in one of the regulations that came from, I think, the judiciary. Should not be defective in drafting, and that we can help them if we have a sitting beforehand. Does not make unusual use of powers conferred by the Constitution. There is no unjustifiable delay in publication. And then this one, which we are using to annul this one, does not inappropriately delegate legislative powers, and does not impose a fine, imprisonment, or other penalty, which is not specified in the Parent Act, does not infringe on the rule of law, and any other reason that the committee may think is necessary. So, Madam Speaker, as we annul this, we are annulling it because, as the mover has said, the registrar has inappropriately delegated powers to herself to be able to give what we are calling to set general guidelines. And general guidelines, Madam Speaker, form part of statutory instruments. So she's given herself powers to set guidelines which will no longer be subjected to the National Assembly. And that is why, Madam Speaker, we feel that this is in contravention of Section 13M of the Statutory Instruments Act, which requires a committee during scrutiny to check whether these regulations inappropriately delegated legislative powers. So I support, Madam Speaker. I second, Madam Speaker.
You second, very well. Members, I propose a question, which is that this House adopts a report of the Committee on Delegated Legislation on its consideration of the political parties funding regulations 2019, legal notice number 143 of 2019, laid on the table of the House on Wednesday, November 6, 2019, and pursuant to the provisions of Section 18 of the Statutory Instruments Act 2013 and Standing Order 210-4B, annuls Regulation 18 of the said regulations. Member for Tharaka.
Thank you, Madam Speaker. Madam Speaker, I rise to support this motion and to particularly agree with the committee in which I sit that Regulation 18 of the regulations be annulled. Madam Speaker, as the seconder of the motion has clearly explained, unfortunately, statutory instruments, which are also known as subsidiary legislation, do not and cannot contain powers to delegate the making of more regulations and rules which actually would not come before Parliament. Parliament is the only authority given the mandate to make laws in this country, and laws in this country are first and foremost anchored in the Constitution. The Constitution can delegate any of its powers, and this is done through an act of Parliament. And an act of Parliament can actually delegate the doing of any act through a subsidiary legislation. And that is where it stops. The only other laws that would follow after subsidiary legislations are precedents, which are set by the courts, rules and orders emanating from courts of competent jurisdiction. Unfortunately here, the registrar of political parties possibly inadvertently, and I say inadvertently because we had a pre-publication scrutiny in which we actually advised her on what she could do regarding other regulations, but this was not part of what we considered. So she may have inadvertently thought that she would give herself the mandate to make more rules, regulations, and orders without having to come back to Parliament, which now turns out to be ultra-vires the Statutory Instruments Act. It is in view of this, we have in good faith recommended that this provision be annulled. And it goes without gainsaying that all regulation-making authorities must at all times observe the provisions of Section 13M of the Statutory Instruments Act, which prohibits delegating of powers to make more general guidelines, conditions, requirements, or whatever they would call it, contrary to that particular section. I do support the motion.
Very well. The member for Taveta, Honorable Shaban Namsi, Commissioner.
Asante sana Mheshimiwa Spika kwa nipatia fursa hii ili na mimi pia niweze kuzungumzia swala hili la kuhusu hazina ya vyama vya kisiasa. Mheshimiwa Spika, yangu kwanza ni kutoa shukrani kwa kamati hii kwa kazi ile waliofanya ili kuhakikisha kuwa mambo ya watu kukaa pali, mtu mmoja kukaa mahali na kufanya uamuzi wa kuwa yeye anakuwa ndio umma, yeye anakuwa ndio kila kitu, ya kufanya uamuzi akiwa peke yake haiwezekani. Bunge hili, wabunge wote hapa nchini tumechaguliwa kuja kuhakikisha kuwa wananchi wanapata haki na haswa umma inapata haki na haki zao sisi tunazilinda kupitia sheria vile zilivyo. Hivyo basi nakubaliana na kamati hii kuwa pale ambapo mwandishi mkuu wa ofisi ya vyama vya kisiasa aweze kufuata sheria vile ilivyo na asiwe mtu ambaye anafikiria kuwa anaweza kufanya kazi akiwa peke yake bila kufuata sheria na kuhakikisha kuwa wakilishi wa wananchi wanahusika kwenye masuala haya na wananchi wenyewe pia wanahusika. Mheshimiwa Spika, naunga mkono.
Unaunga mkono, asante sana. Member for Funyula. Oh, I mean, yes, because I was wondering, you cannot move and you also debate on it, you'll be speaking twice to the motion. The member for Bomachoge.
Madam Speaker, I stand to...
Order. Yes.
I've just interrupted.
Yes, I can see you in intervention.
Yes, I want to ask, is it in order, Madam Speaker, to continue without business, without quorum? I can see a very few. Can you give us direction?
What did I didn't even hear you. Order. You can see you are very few. You must stand, order, honorable member. And I've said this before. You should quote the standing order that you are standing on, that we are violating. So just research and then you do it the right way.
Madam
and
Speaker.
Before you do it the right way, yeah, let the member research on which standing order to do is. In the meantime, as he researches, our members, Honorable Koi Waluka is not in the House, is consulting. There is also a request by Honorable Millie Odhiambo, who is also not ready to debate on this. And therefore, there being no another member interested to speak to this, I call upon the mover to reply. As the member looks at his standing order.
Honorable Speaker, thank you. Let me take this opportunity again to sincerely thank my colleagues in the House for having ventilated and contributed on this important motion. It is important for us to note that funding of political parties is provided for in the Constitution, and each year we make allocations towards that particular vote, and therefore important, knowing the motive nature of the matter, that any regulations, any rules, any guidelines must have the blessings and approval of this House. On that matter, Honorable Speaker, I beg to move that this House adopts the report of the Committee on Delegated Legislation on its consideration of the Political Parties Funding Regulations 2019, legal notice number 143 of 2019, laid on the table of the House on Wednesday, November 6, 2019, and pursuant to provisions of Section 18 of the Statutory Instrument Act 2013, and Standing Order 210, 4B, annuls Regulation 18 of the side regulations. Thank you, Honorable Speaker.
Very well. Pursuant to our own standing orders, and members, the question to motion number 13, that is on annulment of part of the political parties funding regulations 2019, stands deferred. The honorable member, I give you notice. I think now I can hear you well. It's on, and I can guide you. The standing order.
Madam Speaker, I said as per standing order number 35.
Oh, you did say standing order number 35.
I said you never heard about it.
No.
It's standing order number 35.
This is no order.
Is it in order to transact business? We don't have a quorum.
No, yes. Now you are rightfully doing it. Honorable member for Bomachoge Chache, very seasoned member. Now you have done it. It's actually standing order number 30. I was ready to. To guide you, but you have said it very well. It is standing order number 35. So the member is standing on order number 35. That is our own standing orders. That is the issue of quorum. So I do order the quorum bell to be rung. I wish it was 20. Order. Order, members. I order that the quorum bell be stopped pursuant to the standing orders again, the time provided for. Order, members. For us to be able to move, we have to have a properly constituted house. And the time being 6:20 p.m., the house stands adjourned till the Tuesday, 19th November 2019 at 2:30 p.m. I thank you all.